Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin in our Calgary office. I'm here to answer your questions today related to employment law. So, if any of you have any questions related to your rights while you're working, before you start working, or after you've been terminated, feel free to put those in the chat. We're going to try to get to as many of them as we can today. So, feel free to jump in. I was actually just recently writing a post for our blog. We have a lot of information on our blog. We put out, posts almost every day, if not more than once a day, about something that had recently happened here in Alberta. Dr. Hinshaw, who had previously been the chief medical officer for the province of Alberta, of course, many of you know, was terminated when Daniel Smith became premier. She had found a new job working for an Indigenous health organization that was, sponsored by AHS. And when AHS found out that she had been hired, they actually rescinded the appointment. So she lost her job before her first day, which raised an interesting question of, are people entitled to severance if their employment is ended before they even start? And the answer is yes. All right. Once you start an employment contract or agree to start a job, if that job is revoked before your actual first day, you're still entitled to severance. It can happen. People change their mind for a variety of reasons, be they political. That seemed to be the case in Dr. Hinshaw's case, or other reasons. A contract falls through, a budget doesn't get approved, things like that. And then, we thought we had a position for you. Turns out we don't. You're still entitled to severance. So that's definitely something you want to keep an eye out for. Now, of course, your length of service will be a bit of an issue. A lot of people think that your severance is solely based on how long you've worked for the company. That's not exactly correct. Other factors are taken into account, but of course, you're not probably going to get the full 24 months that some employees might be entitled to, but you'll definitely get something, and it might be quite substantial enough to allow you to find a new job. So if that's the situation that you've been in, I invite you to reach out to us. You can reach us at employmentlawyer.ca, and we can tell you a little bit more about your rights. That's employmentlawyer.ca. We have a question coming in from YouTube from M9HO asks, does overtime work need to be pre-authorized by an employer? So that's a great question, actually, because no, the answer is no. All right. So long as the employer, permits you to work overtime, then you're owed the overtime pay. All right. So a lot of employers will say, well, listen, you worked all this overtime, but I didn't pre-authorize it. I'm not going to pay it. It doesn't work that way. Actually, if they permit it to happen, they give you so much work. The only way you can do it is overtime. So you come in on a Saturday and get your work done. And they say, well, I didn't authorize you to come in on Saturday. Well, you gave me enough work to fill a full day of overtime. So I worked it. So now you have to pay it. So absolutely, you're entitled to overtime pay for any hours that you work. All right. So if that's happened to you and your employer is refusing to pay you overtime, what you can do in that case is contact the Ministry of Labor here in Alberta. You contact them, say, look, here are the hours that I worked. I haven't been paid for the overtime. All right. And then they'll investigate and figure out what happened. And then if you are entitled to the overtime, they'll order the employer to pay you what you're owed. Another thing, if some of you are at home and you work consistent amount of overtimes, I have people call me all the time and they say, well, you know what? I used to work, consistently overtime and I never got paid. And I say, well, that's great. We can go for that. We can get you the overtime you're owed. The only problem is people don't keep records, right? If you're working overtime, keep records, right? Keep a journal or a diary, or even in your calendar. I recommend to people, if they're overtime eligible, to have a calendar or a diary where you put your start date every day and your end day every day. And like that, you have a record that you can show, well, look, these are the hours that I actually worked. Now, of course, it's your employer who's obligated to keep track of your hours, But in the absence of anything showing that you've worked overtime, your overtime claim might fail. So I always recommend you keep an eye out, keep a diary of the overtime hours that you're working, so that if you need to make a claim, if your employer is refusing to pay you, well, you have a record showing what your hours were for each and every day that you worked. We have another question coming in from Sam Lupin here. Can an employer penalize you for reporting a health and safety concern? All right. So absolutely not. All right. So employees usually have an obligation to report a health and safety concern under the Health and Safety Act. And under the Act, there's a provision in there that simply states that you cannot be retaliated against for having raised a health and safety concern, or for having tried to enforce your rights under the Health and Safety Act. All right. Now, if the health and safety concern is found to be completely unfounded and had to have been made maliciously or in bad faith, then potentially you could face discipline. But if it's a good faith concern, then you're in the clear, right? You can't be penalized in any way for having made that health and safety concern. We have another question coming in from YouTube from Miss Keisha. My doctor presented a note stating I could no longer work on a night shift, and my employer stated that they are not acknowledging the note and requested certification of my limitations. My question is this something they can do, although my doctor has given a notice of his medical opinion? So yes, they can do this, Ms. Keisha. So essentially what happens is your doctor is telling them how to accommodate you by taking you off night shift. That's not really your doctor's job. Your doctor's job is simply to tell them what your restrictions are, all right? What is it that you can do and cannot do, all right? So if you're restricted from working between the hours of 12 a.m. and 8 a.m., for instance, then that's the restriction. And then you take that to the employer, and the employer will see if they can accommodate you by giving you a day shift job or an afternoon shift job or something like that. And if they can't, then they might say, well, we are unable to accommodate you. Accommodating you might cause us undue hardship, so we can't accommodate you. So the doctor comes up with what the limitation is, what the restriction is. It can be, I can't work between these hours, or I can't lift this amount of weight, or I can't be standing for more than this amount of minutes. And then your employer is the one who has to see if they can accommodate you. So really, the employer didn't do anything wrong here. What the employer should do probably is provide you and your doctor with a form to fill out where the limitations can be indicated. And then once that's filled out, take that back to the employer. The employer will have your restrictions, your limitations, and then it's up to them to figure out if they can accommodate you. We have a question coming in from JX2 asking, how would you calculate severance in BC? I am sure it had long since expired, but in the event world, it is often like gig work, where people have multiple employers and everyone is always hiring. I think what you're asking me, JX2, is whether having several jobs impacts your severance entitlements. So imagine a scenario where you have two jobs. One job you earn, let's say, $20,000 a year, and the other job you earn $30,000 a year. And so you earn a total combined salary every year of $50,000. And then you lose the $30,000 a year job. So how much severance you're owed in that case is dependent, on four main factors. I've talked about them on the show before, which is your age, your length of service, the type of job that you had, whether it was a senior or an executive role or something less, and the availability of similar work. So let's say this $30,000 a year job, you've been there for about a dozen years, and you're owed about 12 months of severance. So are you owed $30,000, or are you owed $30,000 minus the $20,000 that you're earning still from your second job? Well, the reality is you're owed $30,000. Okay. The income you make from your second job in that case is not important, because you were already earning that income before you were terminated. Now imagine a scenario, you lose your $30,000 a year job, which allows you to take more hours at your $20,000 a year job. All right. So now at your $20,000 a year job, you're earning $40,000 instead of $20,000. So at the end of the year, you might still be owed, 12 months of severance, but that extra 20 that you're making now reduces the severance from the $30,000 a year job. So basically, the goal of the severance is to place you where you would have been had you not been terminated after 12 months. And if that had happened, you would have made $50,000 between your two jobs. But because your second job, you were able to increase the salary to $40,000, and the $30,000 a year job only owes you $10,000. Did I miss the first part of your question? Thanks for pointing that out. Sorry about that. Let me go back and read the first part of your question. All right. Sorry, JX2. Similar to the situations you just mentioned, I was hired years ago on-call position and never booked for a shift with a couple different employers. One thing was due to management changes. Yes. Oh, I see what you're saying. So you were asking me, JX2, you were hired but never provided with any shifts, and so would have you been owed to severance? Yes, you would have been owed severance, JX2. You could have said, well, listen, I mean, you agreed to hire me, you never gave me a shift. How much severance you would have gotten, of course, is up to like I was just explaining, kind of in a different way. It's based on your age, your length of service, the type of job that you had, and the availability of similar work. So you would have been entitled to severance. I think it probably would have been in the 1 to 2 month range. In BC, there's kind of a minimum amount of severance that you're owed, which would be usually in the 3 months range. So you could have gone up to 3 months of severance, I would say, if they said they were going to hire you and then never scheduled you for a shift. Important thing to remember about that at JX2 is that you usually have 2 years to sue. So you're saying it was a little bit of a while ago. If it was over 2 years ago, it's too late to sue. So that's the only issue you would have. We have a question from AJ Renee, which is asking, what is my obligation to my employee if a complaint is made against them that seems like harassment to get the employee in trouble or fired? So AJ Renee, your obligation really to both the complainant in a complaint and the respondent, which is the person who's being complained of, is to investigate the matter fairly. All right. So basically, get both sides of the story, figure out what actually happened based on the information that you were able to collect. And then if there is a finding that there was harassment or some other kind of violation, then determine if discipline is needed. And if it is needed, what kind of discipline is needed. And if no discipline is needed, either because the allegation was not made out or because the matter was trivial and didn't rise to the level that it needs any type of discipline, then to inform both parties of that and to put that in their employee files. All right. So I see a lot of employers kind of mess it up when it comes to a workplace investigation. There are lawyers that specialize in just that, in conducting impartial workplace investigations and making sure they're done properly. And then I see a lot of employers that just do it themselves and do a poor job of it. I'll be frank with you. Go in there thinking with predetermined thoughts. Like in your case, AJ Renee, you mentioned that you think the only reason this harassment complaint was made was to get the other employee in trouble or fired. So it seems like you're going into this already having made up your mind and not approaching it in an impartial way. This can create complications later on for you if the results of the investigation are being challenged by either side, right? So be careful. It's important that you be impartial and you try to really get down to trying to figure out the truth of what actually happened. Why was this complaint made? And is it substantiated? So very important to try to be impartial. And if you think you're going to have trouble being impartial, then I would say consider hiring an outside investigator. We have another question here coming in from Ashley Burrows. Ashley asks, my sister has just started her maternity leave and her employer has told her that her position is being eliminated. Can they let her go while she is on leave? So an important thing to remember is that if you're on leave, it doesn't mean the employer can't terminate you. Okay, the employer can still terminate you, be it maternity leave, medical leave, whatever kind of leave it is. They can still terminate you so long as the reason for terminating you is not because you're on leave. Okay, so it's kind of you just kind of got to separate those concepts. So being on leave doesn't guarantee you a job when you come back. Okay. Imagine a scenario where you're on maternity leave and then your whole department gets outsourced to another country, for example. So everyone in your department gets terminated. The employer doesn't have an obligation to keep one job here in this country so for you to come back to work because you were on maternity leave. You get terminated along with everybody else. And the reason it's legal is because you weren't terminated because you were on leave. You were terminated along with everybody else in your department when the department was moved abroad. All right, so that's legal. But if even 1% of the reason of why you were terminated is because you were on leave, then not only that's discrimination. All right, and so you have an opportunity to sue under human rights to potentially get your job back or at least be placed in a similar job. So it's always kind of hard to figure out, what's the actual reason. No one actually goes out there and says, well, listen, this is the reason why we terminated you, right? They might just tell you it's a without cause termination and that's it. Now, in the example where the department got moved, you need to remember all those people are still owed severance. That's a without cause termination. They're still owed severance. But if you're terminated because you took a leave, then you have the right to, of course, your severance, but you also have further rights. You have guarantees. You can be reinstated into your position. The employer is forced to take you back into your position. And the whole time that you were without a position, you can get back pay from the day you were terminated until the day you're reinstated, right? And that can sometimes, there's a case in Ontario, very famous case, where it took 8 years for the woman to be reinstated. She got like over $400,000 in back pay. It was a huge amount of money, right? So that's an entitlement you would have on top of your severance for having been terminated on a without cause basis. So definitely something to consider. So you kind of have to figure out, you can kind of assume that if you're the only person that's let go, it's probably because you were on maternity leave, especially if there are several people in your department and you were the only one that was chosen for termination. But if it's like a mass termination, a mass layoff or something like that, it's harder to say, well, it's because I'm pregnant or I was on maternity leave. If you have 8 or 10 other people who weren't on maternity leave who were also terminated. We have another question coming in from Terry. Terry asks, my employer has asked me to resign from my position. They've said I need to do so by the end of the week. Can they force me to leave my job? So no one can force you to resign, all right? Employers do this so that they can get away with not paying you severance. If your employer wants to terminate you, then they have to provide you severance. So saying that you would rather resign rather than be terminated means that you'd rather not get your severance, which I don't know why you would do that, right? So it's important you tell them, listen, I'm not resigning. If you're going to terminate me, go ahead and do it. I can't stop you. But then I have termination entitlements. I have entitlements to severance, and it should allow me to collect EI, right? Whereas a lot of people who resign, as you probably all know, if you resign, you're not usually entitled to EI. So not only, Terry, are you not going to get your severance, you're complicating your life towards getting EI as well. So you go from having a salary on one day to having absolutely no income the next day. It's not a great position to be in. Whereas we have all these programs, severance, EI, all of this is to help you bridge the gap between your old job and your new job. So why would you give that up? So they can't force you to resign. No, there's no way of doing that, actually. Okay. So that's the question there. We have a follow-up question from Ashley Burrows. The last 3 women who went on maternity leave while working there all also lost their jobs in a similar fashion. Well, that's quite an interesting development, Ashley. It seems that this was your sister who lost her job. It might be that she's been the victim of discrimination, and should be might have significant entitlements. Not only, as I was saying earlier, to back pay. Ashley was the one whose sister was terminated while she was on maternity leave. Not only to back pay, but she could also have the right to all these back wages that she might have entitlement to, and of course severance and all of that. So I invite your sister to contact us if she's looking to see if she can get legal representation. Best way to reach us is to go to our website. I have it up here on the screen. It's employmentlawyer.ca, employmentlawyer in the singular.ca. So feel free to reach out to us. We'll definitely look into that and see how we can help. We have another question coming in from YouTube from Brianna. Brianna asks, can an employer place you on a suspension claiming you didn't show up if you had submitted your request for a vacation day in writing and it was an error on their part? So it depends what kind of suspension. Suspensions come in 2 forms. There's there's paid and unpaid suspensions. So both are a kind of discipline that is short of termination. So as you all know, you can be disciplined at work on a kind of increasing scale. So you can be, a verbal warning, written warning, suspension, termination, generally. Okay. I'm not exactly sure what happened here. If they're acknowledging that it was their mistake, then that seems like an unfair form of discipline. Even if you had just gotten a verbal warning, if it's their mistake, then that's for them to figure out, right? So you definitely want to see if there's any kind of appeal process, and there should be for discipline. Honestly, there should be an appeal process. You should be able to say, well, can someone look at this? I submitted my form. Was it approved? Is the only question I have for you, Wendy. Did you get any approval? And do you need to get approval to take your vacation there? Or do you just kind of put it in the calendar and everyone knows you're away? But if it was, approved, or if it didn't require approval, and then they kind of made a mistake on the back end, that's their problem. It's not yours, right? If, however, they're saying, well, listen, it didn't get approved and you should have waited to get it for it to be approved before taking the day off, that might be what they're disciplining you about. The fact is, yes, we made a mistake in not getting to your vacation request fast enough. But having made that mistake with no approval, you shouldn't have taken the vacation day, right? So that might be what they're talking about. I always say when you get discipline, if you're in disagreement with it, it's important you get your version of facts on the record. You tell them, well, listen, here's your suspension letter. You're putting that in my employee file. I want my rebuttal where I explain my side of the story also put into my employee file. Because, there's something called progressive discipline. So if you're ever disciplined again, the fact that you'd already been disciplined might lead to a more severe form of discipline in the future. And if you want to, and for instance, termination, if you want to go after your severance package, you have now something in the record in your employee file saying, well, I disagreed with this lesser discipline when I received it, and I shouldn't have gotten it. And if a judge agrees that you shouldn't have gotten it, then maybe the termination wasn't appropriate and it should have been something else, right? So if you disagree with the discipline you've received, it's important you put that in writing, send it to your employer, and ask that it be added to your employee file along with the discipline letter that you received. We have another question from Wendy from YouTube. My company has decreased my hours and aren't responding to my questions about why this was done. Is there anything that I can do? So depending on how much of a decrease we're talking about here, Wendy, really your only option is If the decrease is substantial enough, in the sense that your hours have been decreased by 20% or more, 15% really, but it's safer if it's 20%. You can claim constructive dismissal. You can say, well, listen, you're not giving me enough hours for me to support myself anymore. I'm going to quit. But because you forced me to quit by cutting my hours, I'm going to require you to pay me my severance. All right. So cutting your hours, cutting your compensation, these are things that can lead to a constructive dismissal, which is where the employer hasn't said, well, we don't want to employ you anymore, but they've changed your working conditions so drastically that you no longer had the job that you first had when you started working there. You have a completely new job, and no one's asked you if that works for you or not. All right. So if it doesn't work for you, you need to put up your hand and say, this doesn't work for me. Either give me back my hours or pay me my severance. Yeah, those are your options. We have time for one last question from Crystal. Crystal is asking us, my employer is not paying me in my Lluc time payout agreement. We have a signed document that states that if my payout agreement for that this is my payout agreement for overtime. Can they just randomly pay me out for this? Okay, I'm just going to restart because I butchered your question, Crystal. Sorry about that. My employer is not paying me in my Lluc time payout agreement. We have a signed document that states this is my payout agreement for overtime. Can they randomly just pay me out for this? So yes. So basically, if you collect Lluc time, and you have an agreement in place that says, well, if I don't use the Lluc time, I can get it paid out as cash. Then yes, you're entitled to have that enforced. All right. Also, if you either quit or are terminated from your job and you have Lluc time banked, then that should be paid out to you along with your vacation pay when you leave. All right. And if you're terminated, any severance you'd be entitled to. So yeah, it's important to note that Lluc time is money you're owed. All right. They might let you take it as a day off, but if ever you leave the job and you no longer have an opportunity to use it as a day off, it has to be paid out to you. A lot of people ask me, vacation, if I don't use it, do I get it when I leave? Of course you do. Lluc time is the same thing. What about sick days? So generally, sick days don't get paid out to you when you leave. Sick days are generally on a use it or lose it basis. All right. So if you don't use it by the end of the year, it doesn't get carried over, and you don't get any cash equivalent of having not used your sick days. There are certain companies that do let you carry them over and that do let you cash them out, but they're doing that because they've agreed to. There's no law forcing them to do that. But if they put it into a contract or into a policy, then that's still enforceable, but it's not. There's nothing in the law that requires them to do that. But if it's in a contract, it's enforceable, so you can still pursue that when you leave that job. We have actually, this is really the last question. So we have Mariana Popovic asking, when employer denies creation of the new role and tries to take away the same job from an employee while using the tools created by that employee to hire and educate new employees, how do you deal with that? So I think what you're asking me is that you were promised a role, you kind of created some tools for it, and now that role is no longer being given to you and is being given to somebody else. And they're going to use the tools you created to train that other person. It's a bit of a weird one. I think what I'm understanding is that you already have a position with them and they're going to promote you into this new position. So now they're revoking the promotion. I think if you go back to the start of our call today, that revocation could be a constructive dismissal. You could say, well, listen, I agreed to go work in this new role. Now you're saying it's gone and I have to go back to my old job, depending on what the offer letter said. But if the offer letter didn't say that they could return you back to your old job, then you're in the new role as of now. And basically you might be getting a demotion back to your old role and should be entitled to claim constructive dismissal and go after your severance. But if you're not willing to go after your severance, I don't know if you have a lot of options. And that's usually the answer, unfortunately. If you're not unionized and the employer is making changes to your job that you're not happy with, really your option most of the time is, if the change is substantial enough, is to quit and pursue constructive dismissal. You have the right to have a judge look at your case, but a judge is not going to force an employer to increase your hours or to give you a promotion, as we've seen in the show today. Judges don't have that power to dictate to employers how to run their business, okay? The only thing a judge can do is decide whether the cut in hours or the revocation of the promotion was a substantial breach of your employment conditions. And if it was, to award you damages, to award you your severance for constructive dismissal. All right, so important to keep in mind. If you are having trouble, or again, this issue with the in lieu time, it's hard for the judge to force your employer to abide by the agreement. But if you've left the job and they haven't paid out the lieu time, or if there's something in the agreement that says if the lieu time isn't used by a certain date, it gets paid out, and you can have that enforced. But it usually involves you also quitting the job. All right, so that's the complication for a lot of people. So if you're seeing something you don't like at work, the first question to ask is this something I dislike enough to quit and go after my severance for? So that's a very personal decision. If you need some information on what am I looking at in terms of severance, well, we have you covered. My parting words will be to refer you to our severance pay calculator. We have a severance pay calculator. You answer 4 easy questions, and we will give you an estimate of what we think your severance entitlements might be. So that severance pay calculator is found at pocketemploymentlawyer.ca. You have the website address up there on the screen. So if any of you are wondering, well, sure, I'm entitled to severance, how much are we talking about? It can be substantial. It can be up to 2 years of your full salary and compensation. So definitely something you should know about. So visit that site, pocketemployment.ca. All right, so I'm going to sign off. My name once again is Lluc Cerda. I'm the managing associate of the Calgary office of Samfiru Tumarkin. We offer employment law services in BC, Alberta, and Ontario. We have another show starting tomorrow. My colleague Manalina is going to be with you tomorrow at 1 p.m. Eastern Time. If I haven't been able to get to your question today, hop onto the show tomorrow and ask your question early to make sure it gets answered. Thank you all for joining and tuning in, and I hope to see you soon. Bye now.